So our legal panel we have on the end is Satya Narayan. She's an IP and commercial contracts lawyer. She has substantial experience in the AgTech sector, and she has been with the Royse Law Firm for several years. Heidi Klein is sitting next to her. Heidi does trademark, also does trade secret law. Is going to tell us a little bit about our brand new, not quite yet signed into law, Federal Trade Secrets Act. That's something pretty big coming down the way. Adam Thorngate will talk to us a little bit about drones and some other aspects of the law of AgTech. And of course, Riel-Carden is a corporate and business lawyer, also handles regulatory aspects of the field. So with that quick introduction, I'm going to kick this off with Erica and just ask kind of a really broad question here, just about what sorts of problems, what sorts of legal issues should an AgTech company look for, and what do they always tend to run into?
Thank you, Roger. So something that I really enjoy about this industry is the chance to look at different parts of the supply chain. And so not so much a legal issue, but definitely an issue we see with startups is you've developed this really great technology, fascinating technologies, and then you want to apply it to ag. And as a previous grower, I'm so excited to see that. But sometimes the startups don't do enough market research, and so they think, oh, I really want to go direct to grower, DTG, or direct to consumer. And they kind of miss, oh, well, wait, there's processors, handlers, retailers, distributors, manufacturers of product. And so a lot of work we do with startups on the business development side is to say, oh, where else can your technology apply? And then the legal issue side with a lot of startups is I can characterize it generally and say, don't give away your company. And what happens is, most startups die. And we know that. And we know that as founders and entrepreneurs, you're devoting all of your resources to product development and customer acquisition. And when you get to transactions, whether it's formation or trying to issue stock or trying to add a board member, you go to someone like Roger or someone at our firm and you say, I need help with this transaction. And we come back to you and say, okay, it's maybe going to cost $1,000, $3,000, $5,000, and then you go to your co-founder and say, hey, co-founder, CFO, do we have $3,000 to do this transaction? And usually it's no. So, you try and do what you can to get the transaction you try to complete the transaction without the proper legal analysis, and what happens is you give away a lot of your company, more than you're supposed to or should. So on the corporate side, you may not know it, but maybe you gave preferred stock rights for common stock. Maybe you accidentally tried to issue options and you didn't know you needed a 409A valuation to do it. And on the IP side, maybe you had a consultant come in and try to apply your technology to ag and all of those developments. Well, you never had the third-party consultant sign a proper assignment agreement, and now you don't even own the technology. And so when startups come to us and they want to make this business decision, and it's a risk management decision, how much legal risk am I going to give away right now? How much of my company am I going to give away right now? And so I urge any startups in the audience to really think about that. Don't give away too much of your company early on. Thank you.
Okay, thanks very much, Erica. So moving from, I guess, the general corporate to more of the specific technology issues, Satya, could you tell us, I think that summarizes some of the corporate issues around these tech startups, and it's not just AgTech, it's pretty much every tech startup has these issues. But let's talk a little bit about the technology and the data questions. So Satya, what sort of IP ownership and data use issues do you see that comes up in this area?
Yeah, thanks, Roger, for that question. So I think the balance that we have to make when you're an AgTech company dealing with farm data is, there are privacy issues and concerns that farmers have about their data. But from the AgTech company's perspective, you are also concerned about your own IP issues. So, for example, you're going to take the farm data that you're getting farm conditions, yields, farm input information from farmers, and you're going to aggregate that with other information, similar information from other farmers. Now, certainly the farmers are concerned about, the privacy and security of that information and the confidentiality of that information. But from an AgTech company's perspective, you're also concerned that you're taking all of this information, analyzing it, and figuring out the patterns in it, and then developing software algorithms to then predict and give useful information back to the field. Now, the question you have to ask yourself as an AgTech company is, did I get sufficient rights from these farmers with respect to use of their data to be able to do all of these things to create this new IP, which are all of these software algorithms that you're developing? So if your license from the farmers is essentially limited to using their data to provide them the service that you're providing them, it may not be sufficient because you may be using that information, analyzing those patterns to develop new software algorithms, to develop new features, new products, and your license is essentially to use that data only to provide the existing service back to them. So you got to think a little bit more broadly about how you're going to use that data and what kind of IP rights you may need to retain, while at the same time respecting the farmers' need to protect the privacy and security of that information. So on the one hand, while all the farmers and the American Farmer Bureau Federation is concerned about how that data is going to be used from a privacy angle, from an AgTech perspective, AgTech company's perspective, you want to be concerned about, does that license give me sufficient rights to develop these new algorithms, new features, new products, and have I retained and clarified to these farmers that I may do so freely? And usually that's achieved with a balance by including a license grant that gives you a broad enough right to develop these new products, while at the same time clarifying to the farmers that I'm not, I'm going to make sure that it's anonymized and it's not something that can be broken down. The information cannot be broken down to then release, maybe trade secrets or confidential information or the privacy aspect of that data.
Let's pause on that. Can you tell me what that means? I hear that a lot. People say we're going to aggregate and anonymize. What does that mean exactly?
Sure. So aggregation is one thing, where you take data from different farmers, different farms, bring it all together and analyze huge volumes of data, right? So this is, you're aggregating it, taking it all together. It's sort of a totality, and then you're making these analyses. It's really big data. But when it comes to anonymization, that's doing something else. That is making sure that whatever data sets you finally release back to the public or to farmers themselves, it is not information in a manner that can be broken down so that one farmer or one company, one large farming company can look at, oh, that actually is data from my competitors' farms. And now I can figure out what their yields are, what inputs they're putting in, or that kind of information. So the importance of anonymization really is that the data should not be released back to the public or to the user community for that service, where users can figure out, oh, that county had only like 3 large farms, so it's got to be from those 3 farms. If you know how that works, okay, those are the practices they're following. That's really good. Now I know. So, you're linking it up. That's competitive information. So, anonymization is about making sure that one cannot break down that information to figure out which farms are doing what. And that's really important for farmers because, that's, while they want your service to improve their product, they definitely don't want to have, their practices and their methodologies, which makes them competitive, released to other farmers.
I'm going to stay with you, Satya, for a bit here. I know Heidi's chomping at the bit to talk about federal trade secrets, but this is, and this is maybe for Erica also. Erica, by the way, was a farmer before she became a lawyer, so she's got a unique perspective. So the thing, Satya, you negotiate contracts with the biggest companies in Silicon Valley, tech companies, and you're kind of used to how they approach aggregation and trade secret ownership and all of these issues. But ag is different, isn't it? Farmers are a little bit different about their trade secrets. And maybe you and Erica could speak to that a little bit.
So I can just start out as to why maybe that is for some people who don't understand. So farming has always been very innovative. It's all about innovation. We domesticated crops, we mechanized crops, we mass-produced crops, and now we're globalizing crops. And so when you think about that, a lot of people try to compare the ag industry to the automobile industry, and that's okay, but ag is so much older. And the farmers, probably before the 1990s, all of that information, well, how did you pass it down? And it was passed down on pieces of paper, scraps of paper, walking the fields with your children, trying to get that information. And how did you know that certain parts of your acre were missing inputs, were missing needed water? You had to walk it every day. And so for farmers, they really see that and say, I know my land. I'm the only one who knows it. And that's why it's a trade secret. It's what makes them and their crops grow better, faster, and more uniformly than their neighbor's crop. So that's kind of the grower side.
Sure. So from the AgTech companies' perspective, having represented a lot of these companies, and even outside the AgTech field, a lot of a service that is used, AgTech companies try to provide services that can improve yields, can improve and reduce I don't want to say reduce the labor, but reduce the inefficiencies in improving agriculture and the yields of farms. So the way that they get there is of course technology, but also collecting huge quantities of information and data from different fields, looking at them, looking at those patterns, these very patterns that Erica's talking about that, family-owned farms have over, generations written down, figured out what works in what patches of land. All of that information is now being put into these, the service and is being given to AgTech companies, which then take even more information from other farmers to generate this wealth of, patterns that they see. And they simplify it into algorithms, essentially, and they, provide that information back to the agricultural community. So from the farmer's perspective, each piece is a trade secret or is confidential information. Whereas from the AgTech company's perspective, if the farmer wants to be able to actually take their agricultural to the next level, the AgTech companies actually have to take those very same patterns, develop those algorithms, and then give it back to the community. So there is a certain conflict of interest here, but I think it is really more about revealing what one farm is doing right next to the next farm, which may be its competitor or within the region. More importantly, however, is how are these farmers being able to use this service, which is providing all of these new algorithms to do exactly what they've been doing, but take them to the next level, more yields. And so there is a balance that can be drawn, but from an AgTech company's perspective, what you want to be very careful about is you want to make sure that what data you're getting from the farmer, how is it treated confidentially? Is it in the specific details that can be treated confidentially, but ultimately how you use that data to develop patterns and develop software algorithms. Those algorithms, you want to make sure you own those. Because they're developed from these patterns that were generated from the data, you need to have the necessary license to actually go and do the development of the algorithm and keep ownership of the algorithms.
Okay, thanks very much. Okay, Heidi, what is this federal trade secret law I've been hearing about? How significant is it? Why should we care?
Well, thank you, Roger, for the question.
A little closer.
The Defend Trade Secrets Act is a federal law that just passed Congress last week. It's expected to go to President Obama, and he will very likely sign it. He's voiced his support for it. So what it does is it provides one federal action for trade secret misappropriation, a civil action. So we can bring claims against former employees or competitors for trade secret misappropriation. This is significant because currently we have the Uniform Trade Secret Act, but only 48 out of the 50 states have adopted it. And then there's a hodgepodge of state laws that make it very difficult for companies to recover actions. And for example, in California, the threshold to prove that there's been trade secret misappropriation is much higher than in other states. The other significant aspect of it is federal courts are much better at being able to govern actions abroad. A lot of the times when trade secrets get stolen, they're taken to other countries, and it's a lot harder for state courts to enforce those actions.
And just to add to what Heidi was saying, you know, the federal Defend Trade Secrets, the bill that's going to become an act, hopefully very soon, you know, it was lagging in the legislature because the Patent Act improvements and amendments to the Patent Act had been held up. That's gone through, and so we expect actually the Defend Trade Secrets Act to go through very quickly. That said, again, on the trade secrets point, really, when it comes to AgTech, you know, the point that I would want to emphasize, myself being a contracts attorney, is, you know, keep an eye particularly on confidentiality provisions in contracts. You know, there typically, you know, if you're trying to make the contract sound as mutual as possible, you will have confidentiality provisions that are mutual. But, you know, again, make sure then that whatever you're agreeing to keep confidential, you know, whatever farm information you're agreeing to keep confidential, that you have some clarification in the contract about what you can actually do with some of that information if you wanted to develop, again, algorithms and other stuff to improve your service. Again, with the intention is not to take away the farmers' rights, I think, from the AgTech company's perspective. It's actually really to be able to analyze a lot of patterns to develop better products for the farm community. But I think that, you know, the contracts have to be have a lot of clarifications and use language that I think both that farmers can understand. Again, I don't want to sound elitist or something like that, but keep it user-friendly. Let me use that language. Keep it user-friendly and clarify what are you going to do with that data. I think that helps the farmer, gives them confidence and trust in what you do, and you're being clear that you're trying to develop products for them. So that certainly improves the chances that the contracts are, you know, concluded with relative ease.
And to kind of jump on reviewing your contracts, there's a very significant provision within the Act where there's an immunity for whistleblowers. And it actually requires you with your contracts with your employees and contractors to include notice of that immunity. And if you don't include that notice, then you're unable to recover attorney's fees and exemplary damages, which can amount to 2 times the actual damages. And this doesn't apply for whistleblowers, this is with anyone. So even if the claim you're bringing is against someone who actually misappropriated your trade secrets and isn't under the immunity, you lose those, you lose the right to recover those damages.
Okay, I'm going to circle back to that in a minute, but before then, Adam, maybe you could tell us a little bit about the state of drone technology.
Sure, thank you very much, Roger. This time last year when I was sitting up here, we were in a very different place with drone technology. As we all know, drones have been a major advance in technology, not just in AgTech, but across many different technology sectors. This time last year, companies that wanted to use drones in their business had to go through 2 really onerous steps in order to use them. First, they had to go to the FAA. They had to submit an application for an exemption under Section 333, and then they had to go and they had to get a special authorization that allowed them to operate drones within really narrow parameters. And luckily, the FAA has finally started to hear from industry that these are important tools that people want to use in their day-to-day business operations. So there's been 2 major changes, one of them practical and one of them legal, The practical one is that the Section 333 exemption, which used to be something that we kind of had to muddle through, we weren't really sure what the FAA was looking for, has become something that is almost an afterthought. We can submit applications that are almost by form at this point. The FAA used to look at them very, very carefully and make sure that we had complied with all of the requirements. Now that we know what the requirements are, we're able to advise clients much more easily and much faster about what they can and can't do, what the FAA will and won't accept. And for the most part, what the FAA will accept is what most people need to do. So it's an efficient system in a way that it wasn't at this time last year. I haven't checked recently, but when I submitted my first application to the FAA, it took 6 months. There was a backlog that went back all the way into 2013, I think, and they were slowly working their way through it. Now, I think that the turnaround time is measured in just a few weeks. So that's the practical change, and it's had a real effect on businesses. The legal change is that the FAA decided to effectively do away with the special certificate of authorization. It used to be something that you had to apply for. You had to tell them what you plan to do and what kind of heights you plan to fly at and around what and what kind of people. And now they just issue a blanket certificate of authorization to you once you get your 333 exemption. There are restrictions. You have to stay under 400 feet. You have to stay away from airports and heliports and things like that. And there are other things that are pretty unremarkable. If you get into an accident, just like in your car, you have to send a report. The most significant regulation that remains in place is called see and avoid, which is exactly what it sounds like. You've got to have somebody actually at the controls of the drone. So it's understandable, although for AgTech clients it can be frustrating. The certificate of authorization, the constraints that it places on the operations are really easy for most AgTech companies to meet. Most of what we see is that companies are interested in putting sensors of some sort on their drones or receivers that pick up information from sensors that are in the ground. And then they fly at relatively low altitudes over farmland or orchards or things like that, where there's almost no possibility of anyone getting hurt if something were to go wrong, like the drone running out of batteries or a bird running into it or something like that. In other operations, you can imagine how it would cause a problem, but for most of our clients operating in the AgTech space, it's actually a really, really easy set of rules to comply with. So those are some of the real major developments over the past year.
You know, I want to give people an opportunity to ask questions. They say that talk is cheap until you talk to a lawyer. Well, it's free this morning. Okay, we got one in the back here.
Could you give us, 3 takeaways on what's different in the Federal Trade Secret Act that an entrepreneur needs to worry about?
So one of the key provisions is that there's an ex parte seizure order, which is not allowed under the Uniform Trade Secret Act or under any state laws. This means that you can go into a court and under extraordinary circumstances, if you can, to a very high degree, prove that your trade secrets have been stolen, the federal government will go in and seize your trade secrets back. That is not available at this point under any other laws. The other provision, which I mentioned earlier, is the immunity, where there's immunity for whistleblowers, and you must require that in your contracts. So some takeaways for companies. First, you should identify your sources of trade secret information, inbound and outbound. Find out where the information is coming from and how you protect it. The second thing is make sure to review your employee and contractor or independent contractor agreements to make sure that it includes that immunity notice, so that you will be able to recover the attorney's fees and exemplary damages. And the third thing is to make sure that you have a very good process for debriefing employees on the onboarding and offboarding when they leave. Not only does this provide actions for you to go after people, but if you hire employees and they are giving you trade secrets from their previous employer, then you could fall under this as well.
Okay. Other questions? Way in the back there, I see another question. Where's our roving microphone? Oh, I'm sorry. Okay.
I had a quick one. Could anybody on the panel summarize innovations that are taking place from the entrepreneur or farmer's perspective in ag finance? Are there any new vehicles investment-wise or commercial grade lending-wise?
For the investor or for the startup?
I'd rather see it from the startup perspective, but I'd welcome both.
Yeah, so from the startup perspective, there's definitely hints of funds about to go out. But one really good public resource is AgFunder, agfunder.com. I don't know if you're familiar with them. They push out a lot of information. You can apply to their website, and they source a lot of deals for private investors. So that's one major public resource. Another one would be, later on we're going to be talking about accelerators and incubators, which is just generally for startups. But that if you would like to explore that, if your startup's ready for that, you could go that route for funding. Another one, there are a lot of, and I believe, at least on our attendee list, there are a lot of private funds with angels at early seed stage. And even though everyone's kind of holding their breath about the finance, the stock market and everything, they're still out there. They're really interested. We put, $4 billion, Roger?
4.6 billion.
Went into the AgTech sector alone last year, and that's 4 times what it was 3 years ago?
Yeah, it's been growing exponentially. The year we started this 4 years ago, the AgTech sector was a $150 million, at least on a reported basis, in venture capital, which is about the size of Uber, That's how much they took in that year.
One other thing, which I kind of talked about earlier, a lot of startups, when you have your technology, I have a lot of companies come to me and say, I don't want to play with the strategics at all. I don't want to do anything with them. And I laugh because it's like, when you look at the supply chain, the growers, there are tons of resources in the ag community. Their number one trusted source that they go to is the ag retailer. The retailer is the person who provides all the inputs, the chemicals, the seed, the fertilizer, whatever. And so if you're not making your connections around more upstream in the supply chain, that could really hurt your chances at getting investments, even on the early stage. There are trials, a lot of the seed companies, the chemical companies, before they can put a product out, because of all of the strict regulations, they have to trial all of that. And so for startups, if you could come up with some type of arrangement with a strategic where your technology is trialed, then it's tried and true with the growers, it's tried and true with everyone in the supply chain, and that's a really big market opportunity no startups, to my knowledge, are really looking at.
Let me add to that. We have an investment panel coming up that's going to talk a lot more about this, but by far, I think most of the money going into this is corporate venture. It's like Monsanto Ventures, Syngenta, groups like that. The VCs have been very active in the space. We're now doing Series C rounds, so it tells you it's pretty mature. But really interestingly is crowdfunding has been really significant in this sector. These kind of companies tend to lend themselves to crowdfunding really well. And then finally, we're seeing this phenomenon where groups of farmers are forming funds or being angel investors because they want to invest in companies that are going to develop products that they can use and that they understand. So that's this perfect storm for companies looking for investment capital right now. There's a lot of sources. Question in the back.
Yeah, so back on the issue of trade secrets and getting some free advice. What about retroactivity? Is there any retroactive overhang in this new law? And then the second part of it is, what should we do with our existing trade secret contracts and contracts in general where there are trade secret potential exposures? Do we wait? Is there some date in which we should be upgrading our contracts? And again, that ties back into, is there any retroactive provisions in this new law that Obama is going to sign, and when is he going to sign it?
Good question. And no, there is no retroactive issues there. It will become effective when he signs it and moving forward. With respect to contracts that are already in place that may have trade secret issues or exposure, amendments or re-signing agreements, and it kind of, it really affects everyone. So, when you're with the other side to amend the agreement to make sure that those exposures are covered, you come at it from the viewpoint that this is something that both sides want to protect, because the exposure in a contract, especially like Satya said, a lot of these NDA, they're all mutual for the most part. So both parties end up having exposure. So going back, amending, ratifying them.
We have just a couple minutes left. We can take one more question. I'll let the guy with the mic decide.
Hi, this is for Satya, but then for the whole panel. So sometimes, just quickly, my name is Paul Masson, and I backed into the AgTech industry 30 years ago in doing technologies for growing mushrooms so that there was no air pollution, water pollution, or land impact. So sometimes in the current era, there is some a firm that's approaching Silicon Valley to do some software development for an ag production operation. But what the firm actually brings as value is something different, and that I'll call an architecture. So the party is seeking a solution to row crop growing or growing crops indoors, and they're saying, we have this chemistry we know, and we're looking for the software to help us, craft the chemistry and bring it to application. But what the firm really does is it says, well, here's the total architecture you have, which you may not have thought about before. So the relationship with the land, your building, your facilities, the access, the chemistry, the processes is an architecture. So, and I see you're nodding your head and understanding. So the question is, if you've actually helped create the architecture for the company, how do you define that and how do you go about protecting it? Because that's one of the accretions of the migrations that's occurring as more software comes into agriculture, which is this whole concept of an architecture. Who designs it, who owns it, and then how do you protect it? Does that make sense?
Oh, it's a great question. So if you're the firm that's developing the software and you want to then be able to market that software to other companies or other farmers, and you've started with this particular farmer and you got the architecture from them, if you want to be able to sell it down the road to others, then you do need to have very clear provisions in the contract which address exactly that whatever architecture I'm designing, based on whatever information you're providing me, that I, as the firm that's developing it, I will own all of that, and I will be able to, do whatever I want as an owner of that. And then if you are actually the farmer or the organization that's providing the basic, all that information, right? I think from their perspective, the question would be, well, I get that you're going to use all of this wonderful information you're getting from me and you're going to sell it down the road. Maybe that's okay for me, but what benefit do I get in terms of pricing or in terms of other products that you'll be developing down the road? So there's some negotiation that usually happens around that. And also from that party's perspective, one consideration might be, well, I know you're going to develop this wonderful software and this architecture for me, but what if my relationship with your company does not last and I want a third party to start working on this architecture and the software that you develop based on whatever information I provided? I want a third party to then improve it down the road just because my relationship with your AgTech company is, no longer existent. I should have the rights to do that. So that's a negotiation that happens. And I have seen it happen in at least a couple of cases where, the takeaway was that the company developing the software based on the architecture or the design provided is able to then market it to third parties as an owned product. But the party that actually provided the basic design and all that information, which led to the software, is allowed to retain rights in the software, a broad license, including an escrow potentially to the source, to continue to be able to develop that software further using third-party contractors, but only for that particular farmer or organization's purposes,
All right.
Implicit in your answer is that the architecture is defined as one piece of IP and the software is a separate
Uh, That's right. But at the same time, if you are the software company, you want to make sure you have ownership of both, or at least a very broad license with respect to the architecture piece.
Okay. All right, we're going to have to wrap it up here. We're at the end of our time. I'm sure the panel will stick around. I know some of you have some questions.